Welcome, everyone. I am so glad to see some familiar faces and some new faces today. My name is Sarah McAllister. I am the Senior Associate Director here for the Office of Alumni Career and Professional Development. And I'm really excited to have y'all here. Nina Raffo, who is our Associate Director, she will be all things tech. And so if you have anything, any issues, any challenges, feel free to direct message her. A few housekeeping items. So this session is being recorded and will be uploaded to our YouTube channel, which Nina will share in the chat. And you can also access all of our previously recorded sessions through that YouTube channel as well. So if you are so inclined to subscribe, then you will get messages when new sessions are uploaded. Okay, I believe that is it in terms of housekeeping. So I am so excited to welcome Kelsanah and Jake, who are going to be our presenters today and our hosts. As you can see, this is going to be an in-depth introduction to the green card process. And I'm very interested. This is a topic I know nothing about, so I'm excited to be a student today. And with that, I want to say thank you both for being here. Thank you for your time. And I'm going to go ahead and hand it over to you for the rest of our time today.
Perfect. Thank you so much, Sarah. Thank you, Sarah. Thank you, Nina, for helping put this on, and to the entire Tulane community as well. We're very excited to be back here. We did a non-immigrant visa session last year, which is why we're now breaking it into the green card process this year. Yet there's so many different visa categories within non-immigrant visas and green cards alone. So, jam-packing in an hour is very difficult, but Kelsanah and I are going to try to go, through most of them and provide as much detail as we can. So I'll let Kelsanah introduce herself, and then I'll take it back from her, and then we can get started.
Sure. So I'm Kelsanah Wade. I'm an associate in the New York office. I've been at Fragment for quite a bit of time. I actually was a paralegal, law clerk, now associate. I can't get enough. And I, as you can see, was also a Tulane law school student. And you'll see that Jake and I attended at the same time, and we ended up at the same place. So it's just continuation of some great law school fun.
Thanks, Kelsanah. Yep, and I'm Jake Minster. I'm an associate with Fragment in our Boston office. And yep, Kelsanah and I were classmates. We were actually very close in law school, so it's very nice to see kind of how we progressed and the ability for us to do this professionals together. So let's go ahead and talk about the agenda today. So we're just going to give you a basic U.S. immigration overview. We're going to talk about some basic green card concepts, family-based permanent residence and diversity visa green cards. And then we're going to go into some employment-based permanent residence options, the PERM, EB1, NIW, I-140, and I-45, and then open up for questions at the end. Okay, let's get it started. So just to kind of give you a little bit of background into the immigration system, because it is very, very complex, we want to make sure you have a fundamental idea of what we're discussing. So, a U.S. work visa, although we're talking about green cards here, you might think about a work visa or a temporary work visa. It's only needed if someone's physically working in the U.S. So it's not required if someone is outside of the U.S. working for a U.S. company. I get the question a lot, is it okay if I work in the U.S. but I'm on foreign payroll? Do I need a work visa? Yes, you do need a work visa. So it is a physical presence where you are. Immigration law is fluid. It's always changing daily. We can get directives overnight that change the entire process. That just happened with something called the PERM program. We'll discuss PERM later. And it's not always black and white. It's very gray. So processing times differ depending on where applications are filed and what type of application they are. Some categories are way more discretionary. And just remember, the big one is that immigration laws were mostly written in the 80s and 90s. They do not account for technology, especially a lot of the telecommuting that is occurring now since the COVID days. And then this is going to be a really important one, immigrant versus non-immigrant. So whenever we talk about immigrant, it also means a permanent resident. It means a green card holder. Non-immigrant is going to be a temporary worker. So the common categories, O1, H1B, L1, those types of categories. But today we're talking about immigrant green card holders. So just a little background on the government agencies that are involved. We have Department of Homeland Security, Department of Labor, and Department of State. Within those agencies, there are smaller groupings of Customs and Border Protection, United States Citizenship and Immigration Services. So you can see why maybe the process takes a long time. There's a lot of bureaucracy behind it. And on top of that, you have a lot of different interested government agencies that are trying to work together and don't necessarily do a great job of it all the time. Okay, let's get into some other basic green card. So this is what a green card looks like. It is actually a green card. It's not super green, but it has a little bit of shade of green. A green card basically means you're coming to the US permanently. You can't have a green card and then not have the intention to live here. They're numerically limited. There's a visa bulletin we'll discuss in a bit, and you can become a US citizen after 3 to 5 years, depending on how you obtained your green card. So a couple of misconceptions around the whole green card process. You don't have to have an H-1B to file for a green card, although it's recommended that you do because it makes it a lot easier to travel, to continue to have work authorization. But green cards could be filed for people who have never even stepped foot in the US. You could be outside of the US and have a green card application filed for you. You can have multiple different green card applications pending at the same time if you like. And there's green cards for all different types of categories, which we'll discuss as well. And then you can always include your spouse and your unmarried children under 21 in green card applications. So this is like one of my favorite slides, how to get a green card. And you see here's this woman. I don't even think the picture is of her on the green card, but we call it blood is family-based, sweat is employment-based, tears are unfortunately asylum or a similar application, and then luck would be the diversity lottery, which you would be very lucky if you got chosen in that, but people do. So family-based permanent residence can either be a very quick process or it could be a slow process. So it's a quick process if you're an immediate relative, so spouses, minor children who are unmarried, and parents of US citizens. The US citizen is the key piece here. If you're an immediate relative of a US citizen. The slow process is other close family members of citizens or permanent residents can sponsor you. So unmarried sons and daughters, again, and something to keep in mind here, the age for a child is not necessarily 18 in immigration. It would be 21 in immigration. But if a child did get married at 18, they would no longer be eligible to be a part of the green card application with their parents. And it is possible to do married sons and daughters of citizens and brothers and sisters of citizens. It just takes a very long time. I think, Kelsanah, what is it, about 15 years at the moment? Yeah, 20 years maybe. So that is a slow process. It is like a turtle process.
Right, but like Jake said, you can have multiple kind of green card applications or processes ongoing. So if this is one route that you want to pursue, but like let's say you are selected in the H-1B cap lottery, which you discussed in the fall presentation, and you're able to have employment sponsorship for your green card, you can then pursue that. You're not just stuck in your one process. It's kind of like, how do we get there as quickly as possible?
So we've included here the April 2023 Family Visa Bulletin. Basically, the categories that you see on the left side column, this is for family sponsored, not employment based. You'll see F1, F2A, F2B. These are different categories, whether or not you're a spouse of a U.S. citizen or an unmarried child of a U.S. citizen, whether or not you're a brother or sister. F4, I believe, is the brother sister category. And as you can see, March 2007 is the date there that people would have to file an application before this date to get their green card. So the processing times is very long, whereas for other categories, it's not. And if you look at the top row, you'll see that there's an all chargeability areas except those listed. And then there's China, mainland, India, Mexico, Philippines. And the reason they do this is because there is a quota for the amount of immigrants we can have become green card holders each year. And on top of that, there's a quota based on country. So we can't have, everyone from India. We can't have everyone from China, Mexico. So China, India, Mexico, Philippines are the countries that have the most green card applicants per year. So they have their own categories. All chargeability is everyone else. So if you're born in Ecuador, if you're born in Germany, if you're born in England, you're in this all chargeability other area. So the diversity visa, it's 50,000 green cards are given out each year. There's about 15 million applicants, so you could imagine what the odds of getting that is. The odds of getting the Powerball jackpot is almost a little bit similar here. The thing to note is that there are certain countries that aren't eligible. So unfortunately, Bangladesh, Brazil, Canada, China. You can go through the list here. These are areas that are not going to be eligible for this diversity visa. People that are born in Hong Kong, Macau, and Taiwan are eligible, even though mainland China is not. And you can apply for the lottery, at the link below, and the lottery starts in October each year. Although it's a long shot, if you are eligible and you're looking to remain here permanently, I always recommend doing this. It's a very easy process. If you need our help, we'd be happy to help. But a lot of people are able to actually enter themselves in the lottery by themselves. And then this side's just to give you kind of an overview of past winners and who's been approved and issued visas. So Albania, 4,500, Democratic Republic of the Congo, about 4,500 as well. And you can go through the list here and see, what that looks like. And you'll notice that it's all within the 4,500, 4,000 to 5,000 range for each country.
So now we're going to switch gears from family-based to employment-based. And so just quickly, so the employment-based is really focusing on whether or not the foreign national has a job offer from a U.S. employer. So what is happening here is that in order to obtain your green card or your permanent residency is that an employer has to have a job offer for you and sponsor you throughout the entire green card process. There is a few ways to obtain this, and it really depends on the job that's being offered. So there can be a two-step process or a three-step process. The two-step process, of course, is everyone's favorite, and I would like to bypass that first step of the three-step process. And the two-step process is really focused on what's called the I-140 immigrant petition, which we'll get into in more detail later, and it's done with USCIS. And then you'll do an adjustment status application most times, and that the adjustment status application is done here in the US with USCIS. Or for that second step, you can do you can obtain green card through the consular route, which means that you'll be applying with the National Visa Center, and then you'll go through a visa appointment interview at the U.S. Embassy of the person's home country. The three-step process, that first step is not the I-140, it's actually going to be a labor certification, or you'll hear people commonly refer to it as PERM. And so the PERM has to be done, it's done with the Department of Labor, and it is a very involved process, which is why you can only imagine why people would want to skip it and go to the two-step process. But it is a very common way that people do pursue their green card route is that three-step process. And Fragment, this is our specialty. We do it day in, day out. It's something we're very familiar with, and more than happy to assist whomever. But it's a very common process. We will walk you through each step, and we'll definitely go into an overview. So for the employment-based green card categories, there are 5. And the importance of these categories will kind of determine, like I said, whether or not you're pursuing the two-step process or the three-step process. But what's also important, it will determine on whether or not you actually need an employer to sponsor you. In some instances, which we'll highlight as we go on, you can actually self-petition and self-sponsor yourself for a green card. So for the EB1, we have priority workers. Under the extraordinary ability, so So EB1 has subcategories. There's extraordinary ability. There is a subcategory for professors and researchers. Then you also have a subcategory for multinational managers and executives, and we'll go into a bit more detail in a bit. And then for the EB2, we're looking at individuals or professionals who hold or a job is required, a master's degree or higher, and for that particular role, you'll require sponsorship from an employer. There is another EB2 category, which is for a national interest waiver, and for that particular national interest waiver, you can actually, self-petition. And then EB3, we have the professional skilled workers. So for professionals, we're looking at the visa or requirements of a bachelor's degree and 4 years of experience, or you don't require an education requirement, or there's an experience, or there's a very limited experience that's required. And then for special immigrants under EB4, this is for like religious workers. You have also for certain individuals who are juveniles. And then for EB5, we're looking at investors. So individuals who kind of invest a certain amount of money to the US and kind of creating jobs and hiring full-time employees here in the US.
Kelsanah, before we move on, I see in the chat that there are some audio issues. Sarah, Nina, are you also seeing or hearing the audio issues?
I'm not hearing them, but I'm wondering if maybe it's like a microphone thing, just like occasionally covering it or something.
Sure. Is this better?
I can hear you. How is it
Yeah.
for everybody else?
I think that's better.
Yeah.
Okay. I'm gonna be like very zoomed into my camera, so apologies. But I guess it's better to hear me, and I guess you'll very clearly see me. So moving on, so here are the differences between EB1, EB2, and EB3. So like I said, starting from EB1, actually from the bottom, you have the subcategories, and here you have the persons of extraordinary abilities. We're really looking at the top 1%. We have EB2, which is the outstanding professors and researchers, or sorry, EB1B. And then you have multinational executive managers, that's EB1C. So you'll hear people say like EB11, EB1A, EB12. So this is, I know it sounds like a bunch of codes, but as you become more familiar, you'll really understand which employment-based first category someone's referring to. And so we'll explain more detail exactly like what each subcategory, what the requirements are for those particular subcategories. For EB2, we're really looking at individuals, like I said, with an advanced degree. So that's a master's or higher, and actually there's an equivalent. So if you don't have a master's, but you have a bachelor's degree and 5 years of progressively responsible post-bachelor's experience, you can also qualify for EB2. And employer sponsorship is required. And like I said, for the national interest waiver, that's going to be self-sponsorship. And then, of course, EB3 always requires sponsorship by an employer. So here's the kind of what I was touching on earlier. So you have the two-step process or the three-step process. So with the step one, you have the perm labor certification, which is done with the Department of Labor. Only for the three-step process, only once you get through the perm process with the Department of Labor and you receive a certified labor certification or certified perm application, can you proceed with steps 2 and 3. Steps 2 is the I-140 immigrant visa petition. Like I said, that's done with USCIS, and it actually it's one of the only category or the only step where premium processing is available. And premium processing is a big deal because it means you get expedited processing from the government. So right now, premium processing is generally 15 calendar days, but in certain instances, and we'll get into detail about that later, it can be 45. Just admitting someone from the group. Okay, and then for step 3, that's the final step of the green card process. Like I said, you're filing an AOS or adjustment status application, or it's consular processing, which is done with the U.S. Embassy abroad. Like I said, the big benefit for the two-step process, you can bypass that first step of the done with the Department of Labor and just jump right into the I-140 and do it with USCIS.
Yeah, and just one note here too. I know it says EB1, you can skip step 1 and go directly to step 2, 3. You can also do it in EB2, but only if you're filing a national interest waiver, which we'll discuss in a little bit as well.
Right. And then just a quick note, but I'll go into more detail about later. The PD is referring to your priority date, and the priority date is kind of your green light or your ticket or space in line. And when your priority date is current, that will signal to you that you can proceed with filing the last step of the green card process, the adjustment status application or the consular route.
I just one can you go back to that, Kelsanah? I want to hit on this just very quickly. It's important to understand the different steps involved, and typically these steps have steps within them as well. So step one, perm labor certification is the longest step, and that has 3 steps within it. Itself. It's the bulk of the application. But step 2 and step 3, when we talk about concurrent filings, the priority date is very current. The priority date is very important, especially for Indian-born and Chinese-born nationals. And it doesn't matter where you hold citizenship. You could be Indian, born in India, hold citizenship in Canada, but the entire priority date process, which we'll go over, is going to depend on what country of birth you have. So it's very important to understand when you can or you can't file the step 3 of the process.
And great question, Aman, and it actually is a good segue. So your priority date is going to be dependent on your 2-step versus your 3-step process. So basically your priority date, if you're doing a 3-step process, so that includes that first step of the perm application, your priority date is going to be the date that your perm application was filed. If you're doing a 2-step process, your priority date is going to be the date that your I-140 petition was filed at USCIS. So depending on your employment-based category, depending on 2-step versus 3-step, will dictate what your priority date is. And just to emphasize, it really is dependent on your country of birth. We've had individuals who say, well, you know what, I have obtained citizenship in Canada or in the UK. Doesn't that count for something? Don't I fall under the all chargeability worldwide? And unfortunately, you don't. And because there are long processing times, you can only imagine that a lot of individuals want to get through this process as quickly as possible. And so what we really like to do at Fragment, that we strongly recommend to other practitioners perhaps on the call, it's really important to set timing expectations. A lot of individuals, especially from the backlog countries such as China and India, they're pretty well aware of these long delays, but just in case, it's always important to stress that these processes can take a long time. And like I said, only 1 step out of the 3 steps, or the first step out of steps are only allowed for premium processing in some cases. So we're really kind of at the government's mercy in terms of processing, and it really is a first come first served basis.
And just one quick note, sorry, Kelsanah, there's one exception to the rule of country of birth, and that's something called cross chargeability. So
Yes.
if you did move to the United Kingdom, and if your spouse is from the United Kingdom, you could actually go on to step 3 based off of their country of birth, not your country of birth.
Right, and I think that's something we like to look into just in case for a lot of our clients, because if we can take advantage of it, we definitely would want to. And actually backing up to the family base, a lot of times when we're doing the green card and we're about to kick off, the perm or employment-based route, we send out the questionnaires, we receive the completed questionnaires, and then we find out that the person's either engaged or married to a U.S. citizen, and we're like, hey. If you're married already, we could actually pursue the family base if you'd like, and it cuts time significantly, ridiculously actually. So perhaps it's something that you want to explore. So just to keep in mind, again, for fellow practitioners out there, really look at everything. Sometimes being married to a USC may not cross everyone's mind, and so it's just really good to explore and review and assess everything that you receive from your clients. So priority date, I think we have really drove this home, and so I'm going to move on. So here's the visa bulletin for the employment-based visa bulletin. It looks very similar to the family-based that Jake touched on earlier, and so So I'm checking the chat as well. So for the employment-based category, this is for April. And actually each month USCIS will release a new visa bulletin on a monthly basis. They're usually pretty good at releasing it timely, so we can kind of see what to expect for May. For example, like you can see May has already been released. It has gotten a bit hairy at times where they do not release it until like the end of the month prior. And so then you can end up scrambling trying to get things in order. But like I said, they've been pretty, reasonable in terms of when they issue the dates. And so as you can see, it's very similar and exactly the same almost as the family-based employment, the family-based visa bulletin, is that in the top row, you have the different country breakdowns. And in the first column, what we have a breakdown of is the first employment-based category, second, third, etc. And if you go across the line, you'll see that, for example, for all chargeability, EB1 category, the employment-based category 1, that's current. So in April, if that person has everything together for both the I-140, they can actually file both the I-140 and the AOS application, the green card application, concurrently, file it at the same time with USCIS and begin processing. But for example, if you are falling under a category that is, let's see, like you did the 3-step process with the perm, and the perm application was filed in 2020, and you're under China, you'll see, and you're EB2, you'll see that you would not be eligible to file your perm case, your last applicant green card case, because your priority date isn't current. Remember, for the 3-step process, your priority date is based on the date you filed the perm. The one thing to know, and I think this comes up quite a bit, especially for countries that are backlogged, such as China and India, is if you are with employer X and they did the perm process for you, they did the I-140, and you have an I-140 locked in, that is your priority date, you keep that priority date. That is your place in line, and that will carry with you if you move on to a different employer. Let's say you're on H-1B, move from company X to company Z, that priority will be with you. The one thing to know, and I'll get into more detail, is that there might be a few steps that need to be repeated with the new employer in order for you to proceed with the green card. Do you have anything else you want to add there, Jake?
No, I think you did a wonderful job.
Thanks. So moving into, this is personally one of my favorites. I love the perm process. It's funny, when I first learned it as a paralegal, I thought perm was short for permanent resident, but it's not. It's actually an acronym, and it's actually Program Electronic Review Management. So like I said, the first step, the perm, is done with the Department of Labor, and the Department of Labor's interest is to protect the U.S. labor market. So they set forth these rules and guidelines and regulations for any U.S. employer that wants to sponsor foreign nationals. They have to undergo a series of steps and meet certain milestones before they can actually proceed with sponsoring, their foreign national employees for the green card. What's important about the perm and I guess overall green card process, but for the perm, the focus is really on the job itself, not necessarily the individual. And that's important because based on the requirements of the job, like let's say the role requires a master's degree plus 2 years of experience, that master's degree plus 2 years of experience will place that person in the EB2 category. But if the role requires a bachelor's plus 2 years of experience, that will place the person in the EB3 category. So of course, that's something to be mindful of in the requirements, and this does come up during when we have kickoff perm calls with the company and the individual, and maybe that individual's manager in terms of determining what the actual minimum requirements are. The other thing that we're really testing here, and what the company is testing here, is that there aren't any U.S. workers who are able, willing, qualified, and available to fill the offered position as is. And so your testing of the U.S. labor market is actually conducting, or the company conducting, a bona fide recruitment effort. And so we really have to follow these. it's strict. Sometimes it's a bit old-fashioned in the sense of the type of recruitment that we have to conduct. Like for example, like if you're in New York, you would have to take 2 consecutive Sunday ads in the New York Times. I know a lot of employers may not, necessarily advertise in the newspaper these days, but there are strict requirements for the recruiting and the testing of the U.S. labor market that the company must meet and conduct in order to proceed with the certain steps. So the thing to also note is that if there are any, well, let me back up. The perm application is employer specific, it's job specific, and it's location specific. So if any of those 3 items change, it could result in having to start the process from scratch. Of course, you want to do an assessment analysis with your attorney to determine whether or not that actually is going to result in having to start from the beginning of the process. But just keep that in mind, because the perm application, I think a lot of people may lose sight of, is the green card process for a prospective position. So we're really looking into the future. And although we don't have a crystal ball here, we have to do our best to see, if there are going to be any promotions or promotions in anyone's career. Maybe perhaps we do the perm application for that future role, not necessarily role that the individual currently holds, although it is pretty common for individuals to do the perm application for the role that the individual holds right now. And so, like Jake mentioned, there's a lot of sub-steps involved. As I mentioned, we have to do recruitment. But before we get to recruitment, there's actually another sub-step. And this one is the first layer of long processing times, and it's called the prevailing wage request. And the prevailing wage request is a simple form that really covers the information about the job detail. So we're looking at the job title, duties, requirements, location, and submitting it to the Department of Labor, and the Department of Labor will process it and issue what's called a prevailing wage determination. And they're essentially assigning from their occupation database what the best classification for that role is and what the prevailing wage based on the requirements and duties would be appropriate for this particular role. And so once we get the prevailing wage determination, in most cases, then we proceed with the actual recruitment with the company and testing the U.S. labor market. And these are a lot of steps. I always tell my clients, like, I'm covering a lot, but we will walk you through the entire process because there's a lot of moving pieces that we have to keep organized in order to do this successfully. Do you have something, Jack? I saw you came off mute.
Yeah, I thank you for that. Was really awesome and in depth. I just wanted to add a couple of key points here that which you said earlier, but I just want to make sure everyone understands this. For the perm, you have to have a permanent full-time offer from an employer. You can't self-sponsor for the perm. We'll talk about other petitions later that you can self-sponsor yourself for. They're limited, but it is a possibility. And then I just wanted to note that, Kelsanah is talking about the Department of Labor, and then we have to file the case with, once we get to the second step with USCIS. So that's where we're talking about there's different government agencies involved, and we can't move on to the next government agency until the first government agency has really given us the okay. And that's really where a lot of frustration in the process comes, because it takes a very, very long time. Unfortunately, there's not much we can do to speed it up.
Yeah. And like I said, just that initial conversation of setting time expectations is really important. I mean, generally right now, we're really telling clients that the perm process takes anywhere from 15 to 18 months. There have been some improvements in processing times in the Department of Labor's end, but it's not significant. I mean, when I first learned how to do perm, that sub-step, the prevailing wage request, used to take 2 months to process. And now we're looking at something between like 6 to 7 months. So, I mean, of course, there's a lot of factors into why, we have longer processing times from COVID and lack of resources, et cetera. But like I said, just constantly keep everyone abreast of the timing and the processing times, reminding that these are estimated timings because they can change for the worse and even for the better at times. But just keep that on everyone's radar. The one thing is, so once you get through the perm application process, you've conducted recruitment. A U.S. minimum qualified worker did not present him or herself throughout the testing. Then you can proceed with actually submitting the perm application to the Department of Labor. And essentially, you pass the labor market test. If you fail, meaning that the company, conducted recruitment and a U.S. minimum qualified worker presented him or herself, that means you cannot proceed with actually filing the perm application to the Department of Labor. But if you pass, then you can proceed with submitting, and usually we have pretty good success rate across the board. I mean, the Department of Labor very rarely issues what's called audits, and essentially the audit is requesting information about, the business necessity of these requirements. If there's certain triggers in the requirements, such as a language requirement, that usually, will raise eyebrows at the Department of Labor's end, asking, is this actually required, or is this an attempt to, block out U.S. workers so that you can have the benefit of just hiring this particular foreign national? So, I mean, if a language requirement is required, it's required, So, and we've been successful in addressing that as well, in the event of an audit, or in some cases, we've just sailed right through without any question from the Department of Labor. Like I said, processing times vary, and then once we receive a certified application, we have 180 days to complete step 2. If you miss completing step 2, which is the I-140 petition with USCIS, your perm certification is void. That means that you would have to do the process from the beginning. So it's really important to keep track of the expiration date of your certified labor certification.
Really important to have an attorney that will keep track of your expiration dates to make sure that they don't lapse.
Yeah, it can be devastating if you're in that position. One key last point for the perm applications is that you are not for the perm applications, because it's an employer-sponsored application and process. And it's a lot of money. I mean, between all the postings, the recruitment ads, etc. A lot of employers may want to have clawback fees in terms of with the employee that they're sponsoring, and they will say, like, we've invested all this money and this person leaves. We want to make sure that we're kind of, we can recoup some fees. For the perm application, you cannot recoup any fees. Everything is paid for by the company. You cannot have the foreign national at a later date or whenever pay for any step of this process. So I think that's very important to keep in mind. So we talked about a bunch of these points already, so I won't go into too much detail, just be considerate of time. But it's really important that, like we said, labor certification, there's these sub-steps that you have to complete with the Department of Labor before you move on to, and it has to be certified by the Department of Labor before you move on to step 2, which is the I-140, which is done at USCIS. Like I said, the perm application is really focused about the role itself, but at the same time, we have to ensure that the individual that we want to sponsor, that they themselves meet the requirements for the role. The immigrant I-140 petition is really focused on telling USCIS that, hey, we conducted, the labor market test. There's an individual we want to sponsor. Here are the details about the role, and here's this information about the individual and how they meet the requirements for the role. And then the third step, which can be either filed subsequently or it can be filed concurrently, that is really all about the foreign national and their bio, their employment history, their residence history, information about their parents, and at that point of the green card process, can you add like the dependents that Jake mentioned earlier?
Thanks, Kelsanah. So I'm going to take it forward talking about EB1 and EB2 NIW. Kelsanah just discussed the perm process, EB2 and EB3, which most of the time, 99% of the time, is going to require 3 steps of sponsorship. There are certain instances, if you're a nurse or you're a physical therapist, or if you're a teacher, these highly coveted jobs that are typically facing labor shortages in the U.S., you can kind of get away with going step 2 and 3 right away, but that's traditionally not available to everyone. So we're going to talk about EB1 and EB2 and IW. So I'm going to go through this really quickly because I want to make sure that we have time for questions at the end. So EB1 extraordinary ability, for those of you familiar with an O1, it's very, very similar. This is like the green card part of the O1. It doesn't require a permanent job offer. So it doesn't require a job offer or a permanent position. Postdocs can qualify if there's any postdocs on the call. And what's important here is that you can actually self-petition for yourself. You can have a company file it on your behalf, or you can do it on your own. Just to kind of note, extraordinary ability is defined as a level of expertise indicating that an individual is one of those few who have risen to the top of their field of endeavor. Really, when we're looking at these cases, we're looking at people that are in the top 1% worldwide within their specific field. And that might be hard, and I'll give you a little bit of insider knowledge on how we can do this, because you're probably thinking to yourself, how do you even say someone's in the top 1% of their field? Well, we try to narrow the field as much as possible. So for instance, if we were going to say Jake is the top 1% of attorneys, it's number one, it's probably not true. Number two, it's not, we're not going to be able to actually show USCIS that I am. There's just not enough evidence that we would have. So we narrow it down. We'd say, okay, what about immigration attorney? Still a little bit too broad. Let's narrow it down. What about an immigration attorney that specializes in, EB1A extraordinary ability cases for founders? Maybe then we can narrow that field and show that I'm one of the top percentages in that field. So just to note, EB1 is higher than exceptional ability, and it's higher than outstanding ability. And I'll quickly go over some of the criteria. So, you have evidence of national or internationally recognized prizes. These are not prizes that you get for, being honors classes in college. These would be prizes where you actually have to look at the criteria for the prize. Same with the membership and association. You can't just pay to be a part of an association. It has to be a highly coveted association that has asked you to be a member. And we have to provide information about that. Published material about you is really a good one if there is. It doesn't have to be directly about you. It could be about your work, but we'd have to tie that back to you. And we would do that through what's called a reference letter from other experts in the field. Judging the work of others, if you oversee direct reports, this is a good one. If you are a reviewer for journals, academic journals, it's a very good one. So, if you're in the education sector, or if you're in, sorry, just got to pop up, education sector, or if you're in the healthcare sector, this one is usually a pretty good one. Original scientific, scholarly, artistic, or athletic, or business-related contributions, we almost always are going to argue that category. If you don't have that, you probably don't have a strong case. Okay, authorship of scholarly articles, Google Scholar. If you're writing in doing publications, make sure you have a Google Scholar account. Make sure you update it. Artistic exhibitions is really going to be more so people who are applying who are artists or entertainers, or someone who might be, in the Hall of Fame in their home country for baseball, but is not necessarily there yet. In the United States, leading or critical role, that kind of goes back to original scientific scholarly, contributions. High salary is one that's also, we do argue that a lot. I'll just give you two examples. High salary, number one, we have to look at your salary compared to others in the United States. If you're located in India, for say, we can look at your salary in India compared to others in India. And then for founders who typically don't pay themselves very, very high right away, we can actually argue that you've had other remuneration, and that could come in the way of seed funding and angel investments, and that we've been successful arguing that. Okay, I think we can go on to the next slide. So we're gonna, this is the EB1C, it's a multinational manager executive. I just said the last one was like O1 to EB1A. Well, this is L1A to EB1C. I won't go over this slide too much, but basically something to consider is typically what we see this type of green card sponsorship opportunity arise when someone started their career abroad at a company, and then they transferred to the company in the United States. And they have to have been in a managerial capacity abroad, either overseeing direct reports, which is the stronger option, or overseeing an essential function of the organization, which typically we'd look at, you have a high budget, you're working, you're signing contracts, you're You don't have direct reports, but you have indirect reports, that type of information. A lot of people confuse this. If you're on an L1B in the United States, it would be possible, but you can't have been in a specialized knowledge position abroad and a managerial position in the US to qualify for the EB1C. Both abroad and the US have to be managerial positions. To kind of look at how this might work for some of you here in the United States, if you were to get selected in the H-1B lottery, if you're an Indian foreign national and you don't want to wait 11 years to get your green card process, maybe the company that's petitioning for your H-1B has an entity abroad. You can be transferred to that entity abroad for a year in a managerial position, then come back to the United States in a managerial position, and then you'd be eligible to file an EB1C, and you wouldn't have to wait for that EB2 or EB3 backlog. And then this is the EB2 category that we hit on earlier. It's the national interest waiver, and this is the only EB2 category that you can skip the first step of the entire green card process. And basically, it is what it sounds like. You're coming here to further the national interest of something within the United States. Typically, we're looking at jobs that are they're not really defined, but you're looking at jobs that really have the opportunity to further and advance some of the key areas in the United States. So for instance, anything that you're working government contracts with the United States, semiconductor business, possibly depending on what your role is. If you are working in space, if you're working in national defense, those types of areas would possibly qualify. There are 3 criteria for this. Number 1, you have to have an advanced degree. If you don't, there is something sort of like the EB1A test where you have to meet a certain number of criteria. If you have a master's degree or higher, then you go on to this 3 criteria test where it's basically it's really 4 actually, it's not 3. You have to argue that the foreign national's proposed endeavor has both substantial merit and national importance. So that's really 2 criteria in and of itself. And then the foreign national is well positioned to advance the proposed endeavor. And then it would be beneficial for the US to waive what Kelsanah was discussing earlier, that perm requirement for you to just advance in that EB2 category. Right now, under the Biden administration, it is a great category for STEM PhDs. We are seeing a lot of cases approved that would not have been approved under the Trump administration. Kelsanah, did you want to take this part back and we can just fly through it and then open up for questions? You're muted.
Pardon. So really just for the last 2 steps, and we'll fly through because I think we did spend a good amount of time discussing it throughout the earlier slides, but like we said, it can be filed concurrently with the last step of the green card process. But in some cases, depending on whether or not your priority date is current, will be the first step or the second step before you file the last step of the green card process. Like I said, this is the only step that you're eligible to apply for premium processing. What's the great news is that USS has expanded their premium processing to also include other subcategories or other employment-based categories, which has been very exciting. Unlike the 15-day calendars, it's a bit longer, it's 45 days, but it's much better than the year processing times that we were seeing before. So I guess we'll take any advance that we can here. And then last but certainly not least is the adjustment of status application or consular processing. So what's really key is at the I-140 stage, you get the opportunity to indicate whether or not for your last step of the green card process, if you will be here in the US and filing the adjustment of status application. And that is something that is pretty, I think a lot of clients prefer this particular route because it is something that can be done pretty quickly, and there tends to be better processing times compared to the consular processing route. And individuals in H-1B and L-1 status are able to continue to travel internationally as the adjustment of status application is pending with USCIS. For all the other non-immigrant visa categories, unfortunately, they'll be subject to a grounding period here in the US until they're issued what's called an advanced parole document. And the advanced parole document would kind of replace their current visa in their passport. That will be their travel document. And then they can travel internationally once again. With the consular processing route, that is something that, like I said, is done with the National Visa Center. It used to be the one that people didn't want to do, but with COVID, it kind of turned into the quicker processing times, but now it's kind of balanced at this point in terms of processing times. And so it really depends on if an O1, for example, someone in an O1 extraordinary ability category wants to pursue the green card, they might prefer doing the consular processing, because with the consular processing, unlike the adjustment of status, you can continue to travel internationally while their consular application is pending with NVC/the embassy. Do you want to add any other points to that, Jake?
Nope. I think you did a good job. Thanks.
Thanks. But yeah, so this is just an overview of the adjustment status that we just touched on. And like I said, it's really focused on the individual and their bio history, the employment, etc. We do have, what if you are on OPT? You are still eligible to apply for adjustment of status. That is fine. I mean, it's not based on any non-immigrant visa category. So even if you are a dependent and falling under the particular dependent criteria that we listed earlier, or if you're an F1 OPT, an adjustment status application you can still file one. But of course, it depends on your pathway to this particular step. Consular processing. The one thing, it's very similar to the I-140, but the quick difference is there's certain additional documents that you have to obtain for the consular processing. And it's really, for example, it'll be like police certificates from every country that you've lived in since you were the age of 16. And so that's really important to recognize. And so it does require a lot more civil documents than the adjustment status application, but not too much more that it should deter you for pursuing it.
Okay,
and then last tips for
yes, some last tips and general advice. So number one, you can see we're kind of rushing this at the end here, and we apologize. Each step could probably be put into an hour conversation, so we're trying to put this all in here. So I just first want to mention, if you do have questions, we're going to have our contact information up at the end of this. Please feel free to reach out to Kelsanah and I directly. We will review resumes. We'll do a free resume consultation review. We'll let you know some of the options that you might have. But really quickly, what people should be aware of. So keep copies of everything, your I-20s, your EADs, old passports, flight confirmations. Even if you think it's not relevant, keep it. It could be relevant at some time. If you're not sure about something and you're a student right now, an international student, ask your FJ advisor or ask an immigration attorney. If you're not a student, ask an immigration attorney. Alexa's not an attorney. Siri's not an attorney. ChatGPT is brilliant, but they're also not an attorney. Google being not attorneys, message boards are most likely incorrect. So that's something that you should always be aware of. And your best friend is also probably not an attorney. They might be, but I'm not sure. I can't really tell you that. And then lastly, there's nothing worse you can do as an FJ student than work when you don't have work authorization. You might think, oh, I'm getting away with it. You might get away with it next week, next year, in the next 5-6 years, but when it could come back to harm you at some point. And imagine being here through your journey. It's 5, 6, 7 years. Maybe you're Indian born. It takes 11 plus years for you to get your green card, and then all of a sudden at the green card stage, they say, well, it looks like you worked without authorization at this time. You're no longer eligible, and you're going to have to leave the country. So please think about these, whether or not it's worth it before you actually engage in it. So I know we just have a couple of minutes left. Sarah, is it appropriate to ask if people have questions, and they can throw them in the chat and we'll try to get through them?
Absolutely. Yeah, go for it.
Okay. Does anyone have, thank you, Thorben, by the way. Does anyone else have any questions about the process? Again, you can email us as well if you don't want to ask on here. And we'll give
there's
it,
a lot of information that was thrown at you.
Yeah.
So it takes some time to process, and we completely understand. If maybe like once it sinks in that and you'll formulate your questions a bit later, feel free to message us. I'm just going to toss up our information so you can take it down. And then if anything comes to mind, just, feel free to like reach out to us.
And I will also share both of your contact information in the follow-up email to all the registrants. So if anybody doesn't have time to jot it down, it'll also be in the follow-up email.
Thanks, Sarah. Okay, I see there is one question here from Helene. You heard about retrogression, or they heard about retrogression is going on. How long does that usually take? So there is retrogression right now. Retrogression basically means that we can only give a certain amount of green cards per year, 140,000 employment-based green cards per year. And right now, we are getting close to hitting that number already. And the year, it goes not January 1st, December 31st, it's the fiscal year, so October 1st to September 30th. Does it affect work visas? It can. But really what it does is we can't really tell you how long it's going to be or what effect it might have or how long it's going to take. But that's really why it's so important to get through step 1 and step 2 of the process to secure a priority date. And there are ways around if you have to wait and the H-1B is only good for 6 years. If you have, if you have an approved I-140, or if you filed your perm application a year before your H-1B max out date, you do have options to extend your H-1B beyond that 6-year FNIV final non-immigrant visa date. And again, we'd be happy to answer these questions, offline as well.
And also just a quick note, so generally what we normally advise our clients is that maybe starting the green card process about 2 to 3 years out, regardless of your visa category. And I'm sure Jake touched on this in the fall, but certain non-immigrant visas do have a limitation in terms of how many times you can extend. And so that is something that would normally come in once the green card process starts. But if you have specific questions, definitely feel free to, ask your lawyer attorney to address that.
I'll just get these last couple ones really quickly. Russians are still allowed work visas. It's heavily scrutinized. It's hard. There's no embassy in Russia right now, so it's hard to get a visa to come to the United States, but there are other options. Poland is the option for immigrant visa processing, so you go to Warsaw to do that. Does it depend on what country you come from? It does. For the green card process, it's not where you come from necessarily. Like we said earlier, it's what your country of birth is, or possibly where your spouse's country of birth is. And let me see this one. When an employer sponsors you for EB3 visa, does the job being sponsored has to strictly be full-time? It
Yes.
has to be full-time, and I think it's defined as 37.5 hours per week. But unless there's some compelling circumstance or we can show that it's an industry standard, it really, we're going to look for 40-hour-a-week jobs, and that's going to be the safest option.
And just really quickly, talk from the chat. So our firm maintains a client alert, and anyone here can definitely sign up to receive our client alerts. We issue them on a daily basis, sometimes multiple times a day. So in terms of the individual who asks about the retrogression for May, please feel free to refer to this particular alert. It's really helpful, and it really breaks it down into layman's terms. So if you have any further questions, definitely sign up and review that as well.
Thanks, everyone. Thank you, Sarah. Thank you, Nina.
So much.
Thank you so much. Appreciate your time, and thanks for the engaging conversation, everyone. Enjoy the rest of your day.
Bye-bye.